Welcome back to LAWSTACHE channel. My name is Anton Vialtsin. I'm a criminal defense attorney in the Southern District of California here in San Diego. A few months ago, I published a series of videos dealing with vehicular searches without a warrant. Remember, the Fourth Amendment protects you against unreasonable searches and seizures, meaning that usually officers need to have a warrant in order to search your vehicle. But there are exceptions to the rule. In those videos, I've discussed a bunch of these exceptions. And today, we're going to discuss the Ninth Circuit case that touches upon a few of those topics, namely consent and whether detention of the driver and passengers fit within the standard under Terry versus Ohio. In this video, we're discussing United States versus Victor Gonzalez, which is a Ninth Circuit case that touches upon a few topics dealing with vehicular searches. Mr. Gonzalez was traveling southbound and he was stopped by an officer about 58 miles from the Mexican border. Here's why he was stopped. When the officer ran Mr. Gonzalez's license plate, there was a mandatory insurance suspension, which was a traffic code violation in the state of Arizona. Now, the driver and the passenger also gave conflicting answers about their destination. The officer asked Mr. Gonzalez and the passenger where they were coming from and where were they traveling to. And the answers were conflicting, different. About 5-10 minutes later, the officer gave a written warning to Mr. Gonzalez about the traffic violation. At that point, the trooper did not inform Mr. Gonzalez that he was free to leave. However, Mr. Gonzalez turned away from the officer and started to walk towards his own vehicle. So if you think about it, at this point, the traffic stop is complete. But the trooper then asked Mr. Gonzalez if he could have a word with him to ask him a few questions. Without hesitation, Mr. Gonzalez agreed, and he also consented to the search of the vehicle. And then he even signed a written consent form. So the trooper conducted a search of the vehicle. He first frisked Mr. Gonzalez and his companion to make sure that he didn't have any weapons. Of course, he's outnumbered 2-1, and so there's issues with searching the vehicle, having two individuals standing next to him. So he also ordered Mr. Gonzalez and the passenger to stand about 200 feet away from the vehicle. So for his own safety, to make sure that the search goes smoothly. When the search is complete, the trooper finds 10,000 rounds of ammunition. Now, of course, it's not a crime to have this much ammunition, but it does raise reasonable suspicion. So these are the three items that Mr. Gonzalez raised in his suppression motion at the district court level, and now we're in the Court of Appeals, and the Ninth Circuit agrees with the lower court that the suppression motion was properly denied. Here's the first question. We know that Mr. Gonzalez received the warning and the traffic stop was complete. So the question becomes whether Mr. Gonzalez is still in custody. Now, when we ask the question whether somebody's in custody, the legal standard is whether a reasonable person would feel that they're free to leave. Well, in this situation, there were no threats, no guns, and no force used by the officers, or one trooper in this situation. So a reasonable person would be free to leave. And unlike Miranda, where the officers have to give you a warning and tell you they have a right to remain silent and so on, when we're talking about custody, there is no case law that tells the officers that they have to give the warning about custody. meaning that the trooper did not need to tell Mr. Gonzalez that he was free to leave. And so in this situation, the interaction is voluntary. Next, moving on to the search. Well, we know the search was a reasonable one because one of the biggest exceptions to the warrant requirement is consent. In this situation, we have an oral consent, but we also have a signed written consent to search the vehicle. This case should remind you, never consent to any searches conducted by the police. It never helps my clients and it won't help you. And then the other question is whether the search itself was conducted in the proper way. And the Ninth Circuit says, well, the trooper was outnumbered 2-1. There were conflicting answers, and he was unable to see the maneuvers of Mr. Gonzalez and the passenger. So it was proper for him to ask these two individuals to stand back away from the vehicle while the search is being conducted. And finally, under the Terry versus Ohio standard, the officer does not need to have probable cause that the crime was committed, just reasonable suspicion. And in this case, the Ninth Circuit agrees that there was reasonable suspicion that federal crime has occurred because of the 10,000 rounds. It was a large amount of ammunition. And so it was proper for the trooper to handcuff both Mr. Gonzalez and the passenger until the federal agents arrived. So because of these three issues, the Ninth Circuit agrees with the lower court that the suppression motion was properly denied. If you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know.